We will be recording today's presentation session, and it will be available later on our website and social media platforms. If you'd like, you can also enable captions for better understanding. Now, I'm honored to introduce our speaker, Attorney Xiaojie Meng. Xiaojie is a highly accomplished legal professional with a wealth of experience in immigration law. She holds degrees from prestigious institutions, including Fudan University and UC Berkeley Law School. She is also a specialist certified in immigration and nationality law by the State Bar of California Board of Legal Specialization. As a founder and managing attorney of Meng Law Group, she has successfully guided countless individuals through the complexity of the U.S. immigration system. Today, she will be sharing her expertise on topics related to immigration and how international students can stay in North America. We are thrilled to have her with us. Please join me in welcoming Xiaojie Meng. Xiaojie, you're welcome to begin sharing your screen.
Thank you very much, John. It is my honor to have this opportunity today to be presenting to the CAPS members. Okay, I know it's probably almost dinner time there, right? So you guys probably finished your last class just now. Thank you very much for, coming to today's webinar before you even enjoy your dinner today. Okay. All right, so let me see. Okay. Can you see my screen? Okay, so first of all, I'd like to know my audience a little more before I start. I know probably all of you are international students, but I wonder if you're still in school right now or have you already graduated? So if you're in school, can you maybe type 1? And if you have graduated and currently, I assume, working? Oh, okay. Looks like most of you are still in school. Great, great. Thank you for the response. Well, that's very good. So you guys still have plenty of time, to plan your status. So it's really good that you have started planning your status early as possible. It's best that you start thinking about when you're still in school. All right. Okay. So before I start, here's some disclaimer. So first of all, today's material is shared with everybody for educational purpose. This is not intended as legal advice. Okay, even I may be answering some of your questions at the end of the session. Still, that is general information, okay, because I don't know the specifics of your personal situation. So that is not intended as legal advice. And today's material will be shared by CAFs after the session. You're welcome to take notes as you want and, look at it after the session if you need, but please do not distribute on social media or at any other platform without consent. Okay. So a little bit about myself. I'm the managing attorney at Meng Law Group. We are a boutique immigration law firm based in California. But immigration law is a federal law. So we can also represent clients, for clients based in California or outside California. I have been practicing immigration law for 12 years now. So I have been, seeing a lot of policy changes from different administration. I know a lot of people are very concerned right now about, the potential policy change given the election result. If any of you have questions about, any maybe specific rules, any specific policies you have heard, from the media, feel free to leave questions in the chat box. I will get to it after the session. All right. We specialize in work visas and employment-based cases, and also some student status issues, because we handle mostly employment-based immigration cases, including companies sponsoring foreign workers or foreign nationals coming to the US to start business, or they're coming based on their achievements. All right. So today, I know we have a lot to cover because I know I want to just share as much as possible about how to get a green card, how to get the work visas, what are the other common visa types other than H-1B after graduation, like how can you work in the US legally? So that's actually a lot of information. I do not expect you to, memorize all the technicalities from today's webinar, but I do hope, there are certain key concepts you can take, from this session when you're planning your status after graduation. I will mention that as I go over these topics. All right, so first of all, we're going to start from the discussion about green card. So some of you might be wondering, okay, so is that too early to talk about a green card? Shouldn't we talk about some sort of work visa first, right? Like I'm still in school. That sounds really far away. I might not need that right away. Well, that is the first concept I hope you all, kind of take from today's session, that work visa and a green card are two things independent from each other. What does that mean? That means you don't need a work visa to start the green card process. Okay. It also means no matter how long you hold a work visa, it wouldn't lead to green card automatically. So in the US, those two procedures are kind of very independent. Unlike in some other countries, I know in some other countries, you might be given a work visa at the beginning, and let's say after you hold that work visa for like say 5 years, and you're going to be granted a green card. That's not the case in the US. Okay, you always need to proactively apply for the green card. So that's why you might want to start planning the green card as early as possible, or at least be aware of this green card as part of your agenda. At least do not have this wrong idea that after you have the work visa for a certain amount of time you would have the green card. You still need to proactively apply for it. Okay. At the same time, you will also need a work visa. Then here's the question. If you can apply for the green card without a work visa, why don't we just apply for the green card? Wouldn't that be a lot easier? We just get a green card, right? That's a great question. Actually, you may, but the path to the green card is two-step. Okay, so when we are talking about applying for green card, we're not talking about, okay, here's the application, I'm applying for the green card. There are two steps involved. The first, we call it an immigration petition. Okay, so that is pretty much the underlying basis for you to apply for the green card. And you need to prove that underlying basis when you file or someone else files a petition for you. So that can be a family-based petition, like say you are married to a US citizen or you're married to a green card holder. Then the petition needs to prove, okay, this is a real marriage, right? There's indeed this marital relationship between you two. There can also be employment-based petition. Then the employer needs to show there's a bona fide job offer there. There can also be these other, like say, asylum, diversity visas, etc. There you need to prove, that you qualify under that category. So this is the petition where you prove your eligibility for, whatever category you choose to apply from. The second step is the actual filing of the green card. So regardless of the petition type, the second step is always, if you're in the US, it's always adjustment of status. When we talk about immigration stuff, we tend to use a lot of numbers. Okay, you probably will see a lot of numbers. That's usually the form we use for that application. So when we talk about adjustment of status, the form used is I-485. That stands for adjustment of status. It's called adjustment of status because if that is granted, your status would be adjusted from, like say a student or another work status to permanent resident. And then by having this permanent residency, that means you get a green card. So green card is the same thing as permanent residency. Okay, so here's the most important thing. It's like a lot of people would like to ask, like, when can I stay in the US like legally if I start the green card process? Can I just stay in the US if I start the green card process? Well, you cannot stay in the US just because you have the immigration petition. So the first step wouldn't give you any authorization or rights to stay in the US. Only at the second stage, only at the time of filing for that adjustment of status, would you be legally authorized to stay in the US. That's when you can stay in the US waiting for the result on your green card application without having an underlying non-immigrant status. However, generally speaking, we still advise people to keep the underlying status until the green card is approved. But, just in case sometimes maybe your program has ended or sometimes, the applicant unfortunately get laid off. But if the adjustment status is filed, the person can be legally authorized to stay. Okay, so those are the two steps involved in the green card application. So, this is the biggest takeaway from today's session. You have learned that. All right. Then here's the question. Then you might be wondering, then why don't we just file the adjustment of status now, right? Like, let's just go ahead and file the adjustment of status and I can legally stay. Well, it cannot be filed on its own. The adjustment of status, the I-485, has to be filed with a petition. So you have to qualify under some category. Like you have to have like an underlying petition in order to file for that I-485, the adjustment of status. So that's the biggest thing. And for a lot of people from like mainland China or India, there's also this another layer of complication, the visa backlog. Okay, if you haven't heard about visa backlog, we're going to go over that later on. So this is about the green card process. Then why do we need the work visas? Because a lot of times it takes some time for you from the point of filing a petition to the point you are eligible to file the adjustment of status. It can be like a few years. Okay, so you might not be able to use your OPT to fill that gap. Then that's when you need a work visa. So usually you need a work visa because at the time your status, like say your OPT expires, you find yourself still not eligible to file for that I-485, to file for that adjustment of status. That's when you need another status in the US to stay and work legally. Okay, the most commonly used work visa probably is H-1B. I'm sure a lot of you have heard of H-1B. So yeah, that's in high demand. The problem with that is a lot of the for-profit companies, if they sponsor people for H-1B, they have to go through the annual lottery, and the chance is not super high for people to get selected. And there's some other visa types. We're gonna go over them one by one. Still, let's go back to the green card. So we talked about the petition, the adjustment of status. All right. So why can't we just go file the I-485 because we need to file a petition first? But there's something in between. We might need to wait for our so-called like priority to be current. We need to wait for the visa backlog to be cleared before we can file for the I-485. How long does that take? It varies. It varies based on your country of birth and also based on the underlying petition, which category you belong to. Okay, so that can be as quick as like no wait time at all, or it can be a wait time, like say for some applicants born in India, that can be almost like a 10-year wait. So it can be a pretty lengthy process depending on the category and the country of birth. So let's just go over the visa bulletin quickly first. Okay, that's another concept I hope you can take from today's session is to understand visa bulletin. Okay, if you haven't, maybe, hopefully I can give you some basic idea of how the visa bulletin is supposed to be used and how to read the visa bulletin. That is published on the Department of State website monthly. Okay, so when you start the green card process, you probably will go check that page a lot. Okay, probably will wait every month to see, okay, what's the visa bulletin like for this month? Okay, so what I'm copying here is the visa bulletin for this month, November 2024. Okay, so in this chart, you see some country name and you see some dates, and you may see some numbers like first, second, third, fourth, fifth. Okay, this is how you want to read this chart. So first, find your country of birth. Please remember we're talking about country of birth. Okay, so it's the country of birth that determines which line you belong to. It doesn't matter what's your current nationality. That's also a very common question from applicants because sometimes some applicants they might like naturalize in another country, say like Canada, but when they immigrate to the US, they still need to go with the line of their country of birth. Okay, change in nationality doesn't help. So find your country of birth first. For some of you, I know there might be some students today who cannot find their country of birth, maybe here, okay, I wasn't born in mainland China, not India, not Mexico, not Philippines. Where do I belong? Okay, here, all other, the rest of the world. Okay, that's where you should look for your own date. And these numbers, first, second, third, that is the employment-based category. The EB1, EB2, EB3, EB4, and EB5. Okay, so that's the different immigration petition you will file. We are gonna go over that briefly, just to introduce like what are those categories? Okay, so for EB1 and EB1A, EB1B, those are for applicants of extraordinary ability and outstanding researchers. Okay. EB1C is for multinational managers or executives. EB2, EB3, those are employer sponsorship, usually through the labor certification. There's a subcategory in EB2 that is the NIW National Interest Waiver, also for those with some exceptional ability. There's EB5, which is the investor route. You might not see like EB4 here. That's less often used, like less used. That's usually for religious workers. Okay, so I'm not listing it there. How to say, for most of the international students, they probably will go through the EB2, EB3, the employer sponsorship. Okay, but if you are a PhD student, or if you are a bachelor or master graduate, but you have really good publication, you have your own Google Scholar page, you have published multiple papers, maybe you can qualify under the EB2 national interest waiver or even like EB1A or EB1B. Okay, that's also a possibility. So those are the most commonly used categories for international students. Of course, I know some students might be interested in EB5. If you do have those questions, feel free to leave your question in the chat box. Okay, so let's go back to this chart. So let's say today, if you have a bachelor's degree, you graduate and you find a job, the employer really likes you, they decide to sponsor you for the green card, then most likely you're gonna go with the EB3, so the third. Okay, let's say you were born in China, mainland China, and you are in the third category. Okay, here we see a date. The date says April the 1st, 2020. What does that mean? That is the time the person filed the immigration petition. Okay, what is immigration petition? You still remember the 2 steps in the green card application process we discussed just now? So you file a petition first, and then you file the adjustment of status, right? So this is the date you filed that petition. That means, okay, so this is the visa bulletin from this month, and this month is November 2024. It means in November 2024, USCIS, the immigration agency, is approving green card for those who filed, like whose employer filed the labor certification for the applicants before this date. So if their employer filed the labor certification for them before April the 1st, 2022, then in this month, they may get the green card. Okay, so that is like, it's not very accurate, but you kind of get some idea of how long this process takes. Because for those who actually started the process about like more than 4 years ago, like 4.5 years ago, they're receiving the green card right now. Okay, so that is why you need to plan ahead, right? That is why you guys are in a very good position because you're still in school, you're already starting this, so that's very good. Let's say if you are like say a PhD or a master, you have some publications, you publish some papers, right? And then you think you qualify for the national interest waiver, which belongs to the EB2, the second preference. Okay, you might be from a country that's not in these like listed, like not from these listed countries. Okay, then you look at the date, it says March 15th, 2023. That means this month, November 2024, for those who filed their immigration petition before March the 15th, 2023, they may receive the green card. It doesn't sound like too bad, right? Like a year and a half, okay? But let's say if you were born in India, same thing, you filed like the national interest waiver before. And the date here says July the 15th, 2012. Wow, that means for those who filed the immigration petition like a decade ago are receiving the green card today. So you can see like even for the same category, the wait time would vary significantly depending on the country of birth. Okay, so at least I hope you guys can study the visa bulletin. You can play with that a little more, check different categories just to get an idea how long it may take for you to receive the green card. When you look at the visa bulletin, you might see 2 charts. I know that can be very confusing. I just showed you this chart, and if it's the first time you get exposure to a visa bulletin, I feel like, oh, that's a lot of dates, a lot of numbers. And then you all of a sudden you see another chart with a different set of dates. You're like, what is that? Why do we have a different set of dates? That is the date for filing. So sometimes USCIS would allow people to use a different chart with some earlier dates to file the I-485. But I guess right now, if this is the first time you are reading a visa bulletin, you don't need to really know that much nuances. You don't need to really know the nuances of distinguishing the 2 different visa bulletin charts. Just to get like an overall idea of how to read it, I think that should be enough for now. Okay, so this is the priority date. The priority date is from your immigration petition. Okay, let's go back to this one. The first step in the green card, the immigration petition, that would get you in the line of green card. So that is why, starting the process as early as possible, if you qualify, would be nice. Okay, but now that we know the process can take really long, like for some It can be like a year and a half, not too bad. They may not need like a work visa at all if, like, say, if they start in school or the first year of OPT, and they are from a STEM major, they might be able to get a green card by the end of the third year of their OPT. But if it takes like 4 years or even more than 10 years, then of course you need some other status after OPT to stay and work in the US legally before you can file for the adjustment status, right? So the first one I want to introduce is H-1B because that's the most popular work visa. The reason it's popular is because for those of you who have at least a bachelor's degree, you basically have the qualification already. As long as you have a US employer who's willing to sponsor you for a professional occupation. Okay. So but however, as I mentioned earlier, because it's so popular, yet the Congress has an annual limit imposed for this type of work visa. The demand is high, but the supply is not enough. That means every year for those employers who wants to sponsor these professional foreign worker, they have to go through a lottery. So this is the timeline for this year. I would say every year the lottery time would slightly maybe change year to year, but it's always in March. Okay, it's always in March every year to run the H-1B lottery. And the following window for those selected would always be starting from April the 1st, and it ends on June the 30th. So you have like 3 months. Technically, your employer has 3 months to file the H-1B petition for you. So if everything works out, it gets approved, then the H-1B status would take effect from October the 1st. But if it takes longer for your petition to be approved, then your status will take effect from the approval date. So March is the lottery. Following April to June, status in H-1B would start from October the 1st or approval date, whichever is later. The key here is really a willing sponsor, right? So whether the employer is willing to sponsor you is really the key. So if someone like, oh, I really want to get into the lottery pool as soon as possible, but I don't have a sponsor, well, that doesn't really help. But if you have a willing employer, then they can enter you into the lottery pool. In the past, the system is somehow abused by some players because they have multiple employers registering for them in order to increase their chance of selection. However, starting this year, the system has made a very significant change. It is right now so-called like a beneficiary-centric system, which means you are only be counted once if that's the same person, regardless of how many employers are registering you. So that kind of creates a fairer, like I would say, system. But still, the demand is so high. If you might not know, like the quota for H-1B, the annual limit for H-1B is 65,000 plus another 20,000 for those who have like US advanced degree, including like master and PhD. But by the way, for those who have US advanced degree, they can still participate in the regular pool. Like that's 65,000, they can also participate, but they just have this additional chance to participate in this 20,000 additional like pool. So altogether, 85,000. However, the demand, like say, according to the data, would be almost like 3 times of that. That means the selection chance is roughly like 30%. So at least that's from this year's data. We don't know how many registration will be for next year, but from this year's data, the chance of being selected would be about 30%. It has improved compared with previous years, but still it's not even more than half. So that's why a lot of international students would still have to work on their plan B just in case they're not selecting in the H-1B. Okay. All right. There are some changes we expect probably by the end of the year, or at least before President Biden leaves office. There might be some changes, which is good, including like redefine the cap exempt H-1B employer. So if you after graduation you work for school, okay, if you are gonna be a postdoc, or if you work for some research nonprofit, you're exempt from the lottery. You're exempt from the cap. So you don't have to worry about going through lottery. The employer can petition you for H-1B whenever they want. So you don't have to worry about that. But a lot of employers, even they are nonprofit, they may still be subject to the cap, subject to the lottery. But this new rule may relax that a little bit, so more nonprofit would qualify. The new rule also would allow more like entrepreneurs, like those students who want to start their own business to petition for themselves. Right now, that is not allowed. If you are the majority shareholder, you won't be allowed to get H-1B for yourself. So we do expect some changes, but the overall idea is you need a willing US employer to petition you for the specialty occupation, which pretty much means like this is a very professional position that require at least a bachelor's degree in a specific field. Okay, some other common visa types after graduation. The first is OPT, right? We all know like students can apply for the OPT. And then if you're from a STEM major, you can apply for another 24 months. So altogether, you will have 3 years of OPT. Okay. And besides H-1B, there's also the O-1 visa. O-1 doesn't have any annual cap, annual limit, which is great. However, it is more strict with the beneficiary qualification. Not like, you have to meet certain criteria in order to qualify for O1. You have to show you are someone of extraordinary ability in your field in order to qualify for O1. So it does have a higher bar, even though it may not be as high as it sounds like, but still, you need to show like you have certain achievements to qualify for O1. There's also L1 that is for like multinational companies to transfer their managers or people with specialized knowledge. This is also quite common among some big corporations, large corporations, because for those large corporations, they might have like an office overseas. So for those who have used up their OPT time that are not selected in the H-1B lottery, they may send this employee to an overseas company for 1 year and then transfer back with the L1. That is also kind of quite common, but it depends, not every company has like an overseas office, and not every company has like the right position to sponsor this person back to the US on an L1. There's also E2 visa. That is a treaty investor visa. You have to be from certain country. You have to have like nationality from certain countries that has a treaty with the US in order to qualify. Unfortunately, like say for mainland China and India, they're not a treaty country, so they don't qualify. But if you're from those other countries that do have like the E2 treaty with the US, that is also a visa type you may explore. Okay, so they come with their own like benefits, but also the downside. As you can tell, like say for H-1B, it has the annual cap. That is the biggest downside. It also has wage requirements. So if you work for like say some smaller companies, if the employer cannot meet the wage level, then they won't be able to petition for you. For the O1, it is much better. It has these relaxed rules on wage. No other work visas have like really fixed like wage requirement as H-1B does. But say for O1, you do need to meet certain criteria. For L1, you have to be placed like overseas for 1 year before you can be transferred back, right? And for E2, you have to from a treaty country. You can tell like H-1B is really ideal. It doesn't have that high bar, and you don't have to be from certain country. You don't have to work overseas. But because it is so popular, the only downside is you have to go through the lottery. Okay, so these are the kind of requirements for these different types of visa. One thing to remember is any type of work visa, it is employer specific, which means you can only work for the petitioner that petitions you. Okay, it is always initiated by the company. You cannot self-petition for any of those work visas. Maybe for some O1, it sounds like self-petition, but you still have to go through an agent O1 petitioner. So all of them have to have a petitioner, and you can only work for that petitioner during your visa validity. I mean, your approved validity during that time. Okay, I've talked a lot about O1, the higher bar. So this is what it looks like, okay? I may not go to some of the details, but just want to show you what are the requirements for O1. So for O1, there are two types of O1. There's O1A and O1B. O1B are for those who are in arts or in the motion pictures field. Since this is for like the CAPS, I don't think O1B would apply unless some of you maybe, I don't know, in the field of culinary art, that may be a possibility. But I would say for most of you, probably you would need to look at O1A. So O1A, you can tell there are 8 criteria. First of all, you need to meet like 3 out of the 8 criteria. It can be any 3, but you need to meet at least 3 out of the 8 criteria. And then you need to prove, overall, you are a person of extraordinary ability. Okay. Sorry, this is actually not, this is just a reminder, for those in arts and motion pictures, it's different. It's O1B. All right. So if you're in science, your business, education, those are all O1A. I would say for O1A, the most commonly used criteria, like for students, would it be first, authorship of scholarly articles? Because for a lot of students, especially those in PhD program or even master program and some in bachelor programs, they have published scholarly articles. If you have that, great. You have already met one of the criteria, okay? And then some of them may also, because, if you work for, if you have an employer petitioning for you, that means you already got a job offer, right? So if you have a high salary, I mean, how high is high? Well, it's case by case. But if you have a relatively high salary for your field, so you don't have to compete with, those like say software engineer in the Silicon Valley, but you are offered a salary that's considered relatively high for your field, then you meet another criteria. Okay. And then if you plays a critical role for your organization, I mean, the company, maybe the company petitioning for you, well, you meet another criteria, right? Well, how do you prove that, your role is critical? That is up to the company. Usually the company needs to, kind of like articulate in detail why your role is critical. But though, if someone has publication, has high salary, and then get this letter of support from the company to show they played a critical role, they may be qualified for O1A. Well, so it doesn't sound like as hard as it initially sounded, right? But still, you still need to have some achievements. If you're like, oh, I don't have any publication, my salary is not high, my company is not supportive, well, look at the other criteria, whether you have gained any maybe award, you have earned any award. That can be like those maybe thesis award, right? Like for some PhDs, especially, if your thesis is granted award, that may qualify, right? And published material, right? If your name shows in any of the published like media about your work, that can qualify. But those are relatively harder than meet than the three I just mentioned and the most commonly used for recent graduates. Okay. All right, so that's a brief, like a really brief overview of all the work, like commonly used work visas and the procedure to apply for the green card. I know I skipped a lot of the, nuances, details, just want to give everyone like an overview, a framework to work with. If you have any questions, feel free to, let me know. I will, give the floor back to the facilitator.